Hello?
Judge Space Ghost.
Hi.
Good morning, everyone.
Good morning, Judge Robert Highsmith.
Just the audio here too.
Good morning, Your Honor. Andre Hendrick.
Who is at 6349? You are a number, not a name. Might that be Mr. Kendall?
Your Honor, that's Andre Hendrick. For audio purposes, I dialed in and I have the camera on my computer.
Got it. So you are two tiles on here. I can see you right now. Nice striped tie, something in your ear. And then the 6349 is you as well.
Correct.
Got it. Okay. Ms. Crump, you are our court reporter?
I am, Your Honor.
Great. Are you able to hear what we've been talking about so far?
Sounds great.
Great. You don't need to take anything down quite yet. We are missing an important party. Let me make sure, is the courtroom open? If someone was here trying to get in, doors open? Great. Okay. So we'll wait for a couple minutes to see if Mr. Kendall is going to join us. In a kissing cousin relative to this case, Mr. Kendall dismissed things yesterday. So I'm assuming he'll be here. I didn't see any activity in this docket. And I've spent a fair amount of time getting ready for this, so I hope he chooses to join us. In a couple minutes, if we don't hear from him, I will have Ms. Niles reach out to his team to see if we can get an update on his whereabouts. So the rest of you can be at ease. We won't go officially on the record until either I have an announcement as to Mr. Kendall's whereabouts or he joins us. So we'll sit tight for a few minutes. Thanks.
Your Honor, if you can hear me, I'd like to apologize for mistaking your avatar. I think I said Space Ghost. My co-counsel is kind enough to admonish me that that is in fact Speed Racer.
Indeed. Who's Space Ghost?
Another 60s Saturday morning cartoon, Your Honor.
Okay. Speed Racer it is. Ms. Niles, do you mind shooting an email or placing a call to Mr. Kendall's team to see if we can get an update from them?
No problem. I already emailed him. I'll call him right now.
Thank you. Okay. We still don't need to go on the record, but the update I have is that Mr. Kendall responded to Ms. Niles, hey, I dismissed the case. Ms. Niles had to point out, wrong case, that was a different matter, but the hearing for today was on the ORA matter, and Ms. Niles politely asked Mr. Kendall to join us, and here he is. Great. Let me patch him in. Good morning, Mr. Kendall.
Good morning, Judge.
How are you?
I'm doing fine. I dismissed this case on yesterday.
So I'll look in the docket. I don't want to disagree with the dismissal. The news that I received was that you had dismissed the second version of the Love tax refund case. I don't remember the names of the two potential class members that you were representing, but I saw the dismissal of that. Did you also intend to dismiss the Open Records Act case?
No. And I thought this hearing was about that case that I dismissed yesterday.
So Ms. Niles just emailed you the rule nisi that went out a while ago, that is the Open Records Act case. That was the style of the case number, and that's what we have Mr. Hendrick, Mr. Highsmith, the court reporter, Ms. Crump, and myself ready to discuss.
Okay, well, my mistake, Judge. Excuse me. I'm trying to get you back.
Well, I can still see and hear you.
Okay, well, I somehow have lost my video. That's my mistake, Judge. I thought this was about the Cottrell case, and maybe I just didn't read the notice correctly. But what I'll do is I'll pull that up and we can proceed.
Great. You want a couple minutes to do that? And
yes, if you don't mind, give me a minute to bring that file up.
Sure.
Okay, I think I got it back. You give me a minute. Okay, we're on which motion?
So the hearing is to deal with the pending motions, and they're actually a bunch because there've been motions to strike and this and that, but I am viewing today as an opportunity for both sides to articulate their perspective on the cross motions for summary judgment. You also filed a motion for judgment on the pleadings. I'm happy to hear from you on that. I've read your motion and the defendant's response. I'm not inclined to grant that. Doesn't mean I won't listen to you on it, but it struck me that that was premature to try to get resolution to the case at that early juncture, because there had been adequate denials, which is sufficient to defeat the motion for judgment on the pleadings. And so what seemed more ripe for debate were the cross motions for summary judgment. But as you've pointed out, in other settings, there has not been a ruling on the motion for judgment on the pleading. So if there are things you want to say about that, great. I'm happy to focus the discussion to the areas that I'm wrestling with. but I'm always open to hearing from the lawyers about all the issues. I don't want to prevent anyone from being heard on whatever it might be. I think we can table the motions to strike different aspects of different pleadings because I think I can work through the motions for summary judgment without necessarily having to tackle those. But as I mentioned, if folks want to be heard on the motions to strike, we can talk about that as well. But the notion was, because I blocked out my entire morning, we would discuss anything and everything folks wanted to discuss so that I could rule on the pending motions and we could move this case forward. So
Okay.
That's the game plan. Does that work for you, Mr. Kendall?
That'll work for me.
All right, Mr. Hendrick, does that work for you?
Yes, Your Honor.
Okay, and on the defense side, I'm happy to hear from either or both of you. Should I direct my questions when I have questions for Stadco to Mr. Hendrick or Mr. Highsmith?
Your Honor, Robert Highsmith, Mr. Hendrick will be primarily arguing today, and I will step in if I can't help myself.
Okay, so I expect some stepping in. All right, well, let's get on the
Thank you, Your
record. This is 2017 CV 298484. It's the matter of Albert Love and several others as plaintiffs versus the Atlanta Falcons Stadium Company, LLC, Stadco for short. Ms. Crump, our court reporter, is, I say ours, not the court's court reporter. She has been provided by one or both sides together, but Ms. Crump is here taking down the proceedings from this point forward. This matter is also being live streamed, so if there were parties to this litigation who were interested in hearing and seeing what's going on, it's available through the court's website. The courtroom is also open if folks wanted to come on down here. So we are satisfying the open court requirement in a variety of ways. Mr. Kendall has always and continues to represent Mr. Love and his colleagues. And we've got Mr. Hendrick and Mr. Highsmith for Stadco. This is a lawsuit that was filed back in 2017. I think it was November of 2017, alleging a violation of Georgia's Open Records Act. And as I understand it, I'm just going to lay a little foundation as I understand it. Then I'll ask Mr. Kendall to bump me back to what the realities are if I miss something, and then Mr. Hendrick as well. But you guys won't need to cover the things that I've already figured out if I have figured any of this out. Mr. Kendall filed the lawsuit. It alleges 3 counts. The gravamen of the complaint is the violation of the Open Records Act. And as I understand it, Mr. Kendall asked Stadco for the construction contract for Mercedes-Benz Stadium and then the financing paperwork for Mercedes-Benz Stadium. He received a response the very next day from Stadco's lawyers, not Holland and Knight, but I believe it was general counsel, but folks working employees of Stadco, that Stadco was not a public agency and so didn't need to comply. Didn't go very far beyond that. And then Mr. Kendall filed this lawsuit. He alleges the violation of the Open Records Act. And at the time he filed the suit, he had received nothing in response to his request. So it was in his client's perspective, a complete failure to comply with the Open Records Act. He is also seeking attorney's fees on 2 bases, one under the Open Records Act, the Title 15 provision, and the other pursuant to 13-611. There's been an answer. There was a motion for judgment on the pleadings, and then there have been cross motions for summary judgment. And it's my understanding that without admitting that it is subject to Georgia's Open Records Act, Stadco has in fact provided everything that Mr. Kendall's clients asked for, but with some redactions. And initially, both documents, the construction contract and the financing documents, had redactions. Mr. Kendall objected to that. Subsequently, The construction contract was provided completely unredacted. And so the only remaining information that has not been provided, and this is setting aside whether Stadco had any obligation to do it, that's actually what we'll be arguing about. Everything has been provided except some information that Stadco has represented. Bank of America said you need to redact. Bank of America has confirmed that by way of an affidavit, and it's alleged that that's trade secret. And we'll talk about whether it's trade secret or not. But what I want to make sure is the set of facts on the ground is that Mr. Love and his colleagues, if they've taken a minute to look at any of this, already have 1,500 pages worth of responsive paperwork. And the only thing missing is the redacted financial information that was redacted by Stadco. I think it was a paralegal at Holland and Knight, but at the specific request and direction of Bank of America. And I want to be clear, this doesn't mean that there couldn't have been a violation of the Open Records Act. This information was provided long after the 3 days, and Mr. Kendall has made clear that if one of the bases for keeping the redactions in place is that it's trade secrets, that wasn't raised by Stadco's general counsel in his initial objection to providing the information. It was simply, we're not an agency as that is defined in the Open Records Act, so we don't need to give you anything. So that's the basic factual backdrop as I understand it, Mr. Kendall, but add what you want to add or correct misstatements I've made so that I'm not starting from the wrong place.
I think you've accurately described the crux of what the dispute is about. The only thing I think is significant that should be added, and I think I referred to this in my brief, is that the redactions were extensive. So much so to the point that they really take away from the documents that were being given. And as far as the 1,500 pages, I'm not sure if that is exactly accurate, but it probably is close.
But I'm not holding anyone to that exact number. The thrust of it was, it's not that you were expecting 1,000 pages and you've received 3, 2 of which are fully redacted. And your point's well taken. You observed that the redactions aren't like one number on one page and that's it. But at least by your description, there were whole pages that were redacted. To me, yes, the size of the redaction isn't as critical as the basis for it. And of course, one way we can work through this is that the unredacted version can be shared with the court. And based on the position articulated by Bank of America, the third party who actually has asked for the redaction, I can decide if they are overextensive or if they, in fact, fit the parameters of what ought to be protected, if something ought to be protected. But I take your point that it wasn't a single name or one line on one page of redactions. And I wasn't suggesting, as I think one could construe part of Stadco's argument, what's the big deal? If you weigh it, only 4% of what you received was redacted. And of course, that's never the test, because if the nugget you're looking for is in that 4%, then the disclosure really didn't give you a whole lot. If it's all the signature pages, that's fascinating that you got the signature pages, but the thing that your clients are looking for and might be entitled to, they didn't get. So I didn't mean to suggest that somehow the concern raised by your clients is attenuated by the fact that there's so many unredacted pages. But I thought it was factually significant that really off the table now is the construction contract, because those redactions, as I read it, have since been removed. And the only remaining redactions, put differently, the only materials not yet received would be some partial redactions in the finance documents.
That's essentially correct, Your Honor.
Okay. All right.
And
Mr. Hendrick,
I might also add that, this litigation came about because, as I think you said, Stadco disputes the fact that they're subject to the Open Records Act in the first place. And as you also said, that at the time we filed this lawsuit, we had received no documents on the grounds that Statco took that they were not subject to the act at all. And of course, they didn't respond within the 3-day time period or in any other time period. And as you also stated, they took the position that initially they took the position that they were not subject to the act and never claimed that they had an exemption for the trade secrets portion of the exemptions in the Open Records Act that they now claim they are entitled to. And I believe the case law is going to be pretty clear that if you don't raise an exemption defense at your initial response, then you have waived that particular exemption defense.
Okay, and we'll get to the arguments in a minute, and you articulated that pretty clearly in your briefs, and I think the cases that I'm going to want Mr. Hendrick to talk about are the Chua and the that's CHUA and Jaracy, JARAYSI cases, because I think those stand for the proposition Mr. Kendall has articulated. There's another question, which is if what you share with the requester within 3 days, and Statco did respond within 3 days, if what you share is we're not subject at all, do you then have to articulate, but if someone disagrees with us, then we argue this and then we argue this? And we'll discuss that as a group when we get into the arguments. But I just wanted to make sure my limited basic understanding of where we are factually and what's been disclosed and what hasn't, and sort of procedurally was accurate. Because if I was missing something, I ought to know that up front so that I'm not misapplying the arguments that you all are making. Was there anything else you wanted to add, Mr. Kendall?
No, that's it, Your Honor.
Okay, thank you. Mr. Hendrick, anything you want to add about the sort of the factual landscape that I tried to paint?
Your Honor, I think you've accurately summarized the background of the case. As you noted, Statco did respond the very next day to the Open Records Act case. And when we get to it, I'll be more than happy to discuss those two cases that you mentioned that are relied upon by Mr. Kendall and why we do not think they apply to Statco, which is a private entity and not a government agency.
Okay. So let me tell you where I am right now in terms of the arguments that have been very well articulated in the competing motions for summary judgment and the responses there too. And then I'm going to open it up, and I'll start with Mr. Kendall only because he's plaintiff's counsel, but everyone will have a chance to argue and even offer a rebuttal. We've, like I said, we've got all morning. At the time Statco responded, so I think it was October 17th, but the date doesn't matter so much. It was in October. Mr. Kendall sends the letter to Statco. The very next day, Statco says, Open Records Act doesn't apply to us. We're not doing work on behalf of an agency. At the time that letter was written, I would have disagreed with it because to a lay person, what do you mean you're not doing work on behalf of an agency? Georgia World Congress Center, they're interested in having a stadium built and you're building it and you're leasing it from them. Of course you're doing work on behalf of an agency. And so if one looks at the literal language of 50-18-70B2, which is the operative provision, it seemed like Mr. Kendall was not barking up the wrong tree. But maybe those lawyers had a crystal ball or they guessed just right, because having read Northside now probably 3 times because the sides kept coming back to it, the way the Supreme Court has defined on behalf of in Northside, as I read it, is that the work that the private entity is doing on behalf of the agency must be work that the agency otherwise would have to perform. such as, most obviously, the hospital authority. And if Northside, the nonprofit entity, ceased to exist or said, we're moving to Southside, the hospital authority would still have to do what Northside was doing for it. Or in Justice Peterson's example, he created a scenario where there was a city ordinance that required the city to collect the trash. Not that it should or it could, but that it had to. And it then contracted that out. It had to do it. It got someone else to do the trash pickup for it under his and ultimately the majority, well, that was unanimous opinion, the court's interpretation of that language on behalf of requires that the work being done is something that the agency otherwise would have had to do. I think Mr. Hendrick called it the have to perform standard, which was a helpful way to formulate it. That is not verbatim what's in the statute, but that is what the Supreme Court has said the statute requires. And given that interpretation of 50-1870 B2, and the way that the World Congress Authority's charging statute reads, I don't see how the GWCCA was required, obligated, directed to build a football stadium or sports arena, call it what you will. It elected to, it could, it had the authority to, but it wasn't required to. And in pursuing that opportunity that it was allowed under its authorizing statute, its charging statute, it farmed that out to Stadco because they reached an agreement. But I guess I want to start with you, Mr. Kendall, because for me, this is the heart of the matter. And we'll talk later about trade secrets and whatnot, but frankly, we don't get to trade secrets. We don't get to all of the, do we need to strike this portion of a brief here or there? If in fact, Stadco's read of Northside is accurate. And I will say they seem to be reading Northside as it is written, not as they wish it was written. They're not adding words to Justice Peterson's language. The have to perform is in there. That's what he said, and his specific example, a simpler thought experiment than the complexities of the hospital authority about the trash pickup. That's specifically how it was structured. So, Mr. Kendall, one, you can tell me why I'm wrong in how I'm understanding Northside, or two, you can say, yes, that's what Northside means, but here's how the World Congress Center falls nicely under that same rubric. Or three, you're a smart guy, you may have something completely different that you want to argue in that area. But that's where I'd like to start, because that's where I find myself landing, having immersed myself in your various briefs, Mr. Kendall, and Stadco's various briefs. And conveniently, they're well written. That always helps the judge. But the two motions lock horns over this. And so I feel like I have been tugged nicely in both directions by both sides. So I'm now ready to listen.
Well, I think you have an overly restrictive interpretation of have to. I don't think the statute certainly doesn't restrict it to that degree of limitation. And I don't read Northside to restrict it to that degree of limitation. There's a case called Hackworth versus Board of Education of the City of Atlanta, where records of school bus drivers.
Is this case older or newer than Northside?
It's older than Northside.
Okay, what's the citation?
The citation is Hackworth versus Board of Education of the City of Atlanta, 214 Georgia Appeals 17.
Okay.
It's cited in my brief on page 6.
Okay. And when you say your brief, it will help me. I have
my summary judgment brief, I'm sorry.
Your motion for summary judgment as opposed to your opposition to theirs.
Yes, my motion for summary, your brief in support of my motion for summary judgment.
All right.
That case dealt with a request for school bus driver records of the drivers that were employed by a private company. The court ruled that the records in the hands of the private company were subject to the Open Records Act. Not because the school board had to provide transportation and drivers to drive students to school, but because the school bus transportation issue was an integral part of the course of operation of the public agency. So when you limit the have to language in Northside to had to or was required to, then I think you've engaged in an overly restrictive interpretation of that language.
Okay, and when you say that language, you're saying interpreting or applying the Supreme Court's language, because of course the had to is not in the statute.
Right, exactly.
Okay.
And therefore I think when you engraft that limitation onto the statute, you are basically changing the meaning of the statute.
So the fact that Hackworth is an older lower court opinion in your mind doesn't mean that it was effectively abrogated. I don't think it was directly overruled. I didn't see a list of cases that were overruled by Northside, but you think that there's not tension, or there may be tension between the two, but it's reconcilable because of the integral nature of the work that the school bus service provider was doing for the school district.
I don't think there's any tension at all. I think that Northside is completely consistent with Hackworth.
Okay.
And that's why the Supreme Court didn't limit Hackworth, didn't talk about Hackworth being off base, and certainly didn't overrule Hackworth. And the statute itself says private entity that performs services or functions for an agency. And certainly STATCO performs services and functions for the Georgia World Congress Center Authority.
It does, but let me quote to you from Northside, the what I'll call for STATCO, the magic language. A private entity acts, and then in quotation marks, on behalf of, that's the magic phrase from the statute, a government agency, when the agency arranges for the private entity to perform a government function. And now this would be where the defense would say, emphasis added, that the agency would otherwise have to perform. So
Yeah.
how do you give meaning to those words that would be consistent with I haven't read Hackworth, but assuming Hackworth says school district was not required to provide bus service, but that's not a reason to find the bus company not acting on behalf of the school district. It's just important that buses are provided, and no, the school district didn't have to do it, but they chose to, and they farmed that out to a private entity, and that private entity is subject to ORA. How do you square that with the language, otherwise have to perform?
Very easily. The first part of what you just read has to be read in harmony with the second part. The statute has to be read in harmony with all of its parts. The statute clearly says that a private entity performing services or functions on behalf of a public agency. That's what that quotation that you just read from Northside says, on behalf of. And the have to part is just simply modifying the on behalf of, not that it eliminates the on behalf of, but it modifies it and has to be read consistently with the statute itself that says nothing whatsoever about an agent performing services or functions that an agency had to perform.
So did it not seem instructive to you in the North Side opinion that Justice Peterson spent so much time dissecting the charging statute for the hospital authority and all the things that the hospital authority had to do, to include the observation that if Northside ceased to exist, the hospital authority would have to do exactly what it had contracted out to Northside to do. And that was part of his discussion. Why go there if the have to perform doesn't mean what Stadco is arguing it meant? And I know you're not crawling inside Justice Peterson's mind, but it doesn't make sense to spend 2 pages of the opinion poring over all that if that's not the thrust of the opinion.
If Stadco ceased to exist, then the Georgia World Congress Center would have to perform the functions that Stadco is performing at the Mercedes-Benz Stadium, similarly as was the case in Northside. In fact, the Georgia World Congress Center did in fact perform the same exact services that Stadco is performing when it ran the Georgia Dome.
I've seen your chart where you list all those things.
Yeah, so what I'm saying to you is that the Northside case is even more attenuated in terms of having to perform services and functions on behalf of a public agency than this situation is. So I don't see any tension or incongruence at all with what's going on here as opposed to what went on in the Northside situation.
Okay.
In fact, I think this case is even stronger than the Northside situation because of the history. The history being that the Georgia World Congress Center performed at the Georgia Dome the exact same functions that it later contracted out to Stadco. So that if the Georgia World Congress Center had never decided to build a new stadium and grant to Stadco the opportunity to lease that building, it would still have been performing those same exact services in the Georgia Dome that it contracted out to Stadco to perform in the Mercedes-Benz Stadium.
And to you, it doesn't matter that the World Congress Center Authority was performing those services of its own volition. In other words, it wasn't required to. It would not have been in derogation of any of the statutes governing it, creating it, if it said, you know what, we're not going to build a stadium. We choose not to do that. We don't have to, or we'll help get the stadium built, but then we're stepping back. It's not our job to manage merchandise or provide security. Why would we want to get in the middle of that? We're the authority that is tasked with this area of the city and managing certain ventures that are authorized, not required, but authorized under the statute. That doesn't make a difference in your analysis.
Not at all, because that was the reason the World Congress Center was created, to provide venues for sports and entertainment activities.
Okay.
That was their core function. That was the reason that they were created, to provide exhibit space and venues for the performance of sports and entertainment.
If McBurney Janitorial Services was hired to clean Georgia World Congress Center's offices, would my company doing work on behalf of GWCCA be subject to the Open Records Act?
In my view, yes. Any private entity, the records of your company, that is, would be subject if you are providing a service or a function to a public office or agency that agency otherwise would be performing or required to perform, then you are subject to the act. Now, in Northside, what happened there was that the hospital authority farmed out to a nonprofit the operation of a hospital, and then the hospital purchased certain practices, certain medical practices. So the hospital authority was twice removed from the actual records that were sought to be obtained by the private entity that requested those records. They were not in direct privy to contract with the entity or the records that were being sought. So that's why I say this case, the scenario here is even stronger in terms of the on behalf of performing a service or function on behalf of a public agency or office. So if you, the janitorial service had a contract with the public entity, and you were performing services on behalf of that entity, that entity would otherwise perform in the course of its normal operations, then yes, your entity would be subject to the Open Records Act.
So if the World Congress Center Authority was throwing a party for its staff because they had worked hard, secured the contract with Stadco, and they rented a bounce house for kids of employees. Certainly nothing that the World Congress Center has to do, not part of its charter. Would the business records of the amusement company that provides the bounce house to the GWCCA employee party, paid for with GWCCA funds, would that be subject to Open Records Act?
The records of the bounce house, insofar as the party was concerned, would be subject to the Open Records Act. The bounce house's records with regards to all its other customers that had nothing to do with the Georgia World Congress Center would not.
Okay. But
Okay,
whatever records Bounce House Company had in connection with its work it did for the World Congress Authority, your contention is that those records would be obtainable, not through GWCCA, obviously an agency, but they'd be obtainable through McBurney Amusements by way of the ORA.
Yes, with regards to the services and functions that it provided to the GWCCA, yes.
Okay.
But with regards to any other entities that it was doing business with, no, because it's not performing any service or function for a public agency when it does that work.
Right. Okay.
But in this case, with regards to Stadco and the Mercedes-Benz Stadium and the financial records that we seek, all of that is directly related to the work it performs for the Georgia World Congress Center Authority, and all of those records, financial records, and going beyond what we ask for, any other records, i.e. financial records, sales tax records, records with regards to its restaurants that it has leased space to, or anybody else that it has leased space to in that building, performing functions for the Georgia World Congress Center, just like they were done in the old Georgia Dome when the Georgia World Congress Center itself maintained and managed that building. All of those records are public records under the Open Records Act.
Okay. And I wasn't suggesting that there was some aspect of what Stadco does in its relationship with GWCCA that was analogous to the amusement company that might have all these other customers. Stadco doesn't also operate a stadium in Tennessee, and you're not trying to get that. I appreciate that your focus is solely Stadco work that is being done on behalf of and in connection with commercial agreements with GWCCA.
That's correct. Stadco is in effect, by virtue of the agreements, the plethora of agreements, I don't know, some 15 to 20 agreements that it has executed between it and the Georgia World Congress Center. it is in effect the alter ego of the Georgia World Congress Center insofar as the maintenance and operation of the Georgia World of the Mercedes-Benz Stadium is concerned. And the whole import of that provision B2 in the Open Records Act is that a government agency should not be allowed to transfer records to some private entity and thereby shield those records from public scrutiny when those records pertain to the operation of that public agency or office. And that basically what Statco is saying, that is because first of all, they're saying we're not subject to the act. Then secondly, they're saying that we don't have to give you what we don't want to give you if we don't want to give it to you.
Well, what I've heard them say is yes to the first part, not subject to the Open Records Act. But if you find that we are, the redacted portions were appropriately, and by this I mean only the redactions to the financial documents, were appropriately redacted because they're a trade secret, not because we just don't want to give it to you. I mean, they provided a basis. Was it timely or not? We'll talk about that later this morning. But I don't think it's quite the way you described it. All right, anything else you want to add on the applying Northside to the facts of this case?
No, sir. I think I've said it all.
Okay, well, I appreciate that. And I will make sure I read Hackworth. I saw how you incorporated it on page 6 of your brief, but I'll dive into that and see what I find there. So, Mr. Hendrick, I'd like to hear Stadco's view on how Northside applies, and in particular, responding to Mr. Kendall's concern, as articulated here and in his briefs, that Northside, as you would apply it to this case, and it's really in the language in your briefs, that it severely restricts or narrows the circumstances in which a private entity acting on behalf of a public agency is subject to ORA. Because we began to hear at the end of Mr. Kendall's argument here, you know, this is hiding records, it's pushing public records out of the public eye by, this is not my word, secreting them in a private entity that is effectively, this was Mr. Kendall's evocative phrase, the alter ego of the World Congress Center Authority. And for public policy reasons, of course, we wouldn't want that to happen. But if Northside says what you argue it says, and it appears to say on its face, that's where we are right now with how that statute works. So take it from there.
Your Honor, I want to start by saying that I do agree, Stadco agrees with your comments about Northside and the manner in which it appeared you're reading Northside and the emphasis that Justice Peterson has placed on that language in the statute and the interpretation of what on behalf of means. And I think it is notable to mention that Justice Peterson, before taking his current position, spent a significant amount of time revising the Open Records Act. And now in his current position, he is able to put a gloss on exactly what he meant when he worked on it and when the language of the Open Records Act was revised. The position that Mr. Kendall has taken calls for a far more expansive application of the Open Records Act than the statute calls for, or that would even make sense. What Mr. Kendall has in effect argued is that anytime a private entity contracts with a governmental company, that private entity itself becomes subject to the Open Records Act with respect to any and all documents or records it may maintain that are in any way connected with that contract. And that is simply not what the Open Records Act says, and it's not what Northside says. And with respect to the case, the Hackworth case.
I'm gonna
Yes.
pause you there because help me understand how that's not what the Open Records Act says. Your argument was Open Records Act doesn't say what Mr. Kendall is arguing, which is if you are a private entity doing any kind of work on behalf of a public agency, then your records generated, maintained, received in connection with that work are subject to the ORA. You're saying that's not what the statute says, and it's not what Northside says. I agree with you on the latter, and I'll tell you why I initially struggled with this is that I don't agree with you on the former. Read literally, the 50-1870 B2, it doesn't have any limiter in it saying, well, and it has to have been something that the agency was required to do. And so my example of hiring the McBurney cleaning crew to clean the Georgia World Congress Center's offices, they're not required in any statute to clean their offices. I mean, maybe OSHA would come in to say it's dirty in here now, but they're not required to do that. And so kind of logically, that seems like a stretch to say McBurney Cleaning's records in connection with the cleaning services it provides to the offices of GWCCA, that falls outside the ambit of the statute. But as written, it seemed to me facially that Stadco's work would fall right in the heartland because it is doing all sorts of work on behalf of, and I'm not persuaded the fact that GWCCA used to do it at the Georgia Dome means that it's covered. It's what it's doing now, and it's doing it on behalf of the World Congress Center. Why do you say the statute as written would exclude Stadco's work in constructing and financing and operating the Mercedes-Benz Stadium?
Well, then let me rephrase what I said and instead say the statute as it was interpreted by Northside, which is a 2017 opinion by the Georgia Supreme Court, which specifically addressed what that language on behalf of in the statute means. And the court said, in the context of the statute, a private entity acts on behalf of a government agency when the agency arranges for the private entity to perform a government function that the agency would otherwise have to perform. And Justice Peterson reinforces that point later when he says the law thus does not permit the authority to get out of the healthcare business altogether. So he's reinforcing the point that in that context, conceivably, that there are documents that would be public records because they are significantly related to functions that Northside would have been performing that the authority would have otherwise had to perform. And that kind of spills into another one of the elements, which is this nexus, this connectivity between the documents that are being sought and the government function that is being performed. And I think you got it right here when you were talking about how the GWCCA has absolutely no obligation to house a NFL sports arena. We just saw the Raiders move to Las Vegas. If the Falcons decided that they wanted to go become the Oakland Falcons, they could do so, and the GWCCA would have absolutely no obligation to continue to operate Mercedes-Benz Stadium. If they wanted to, they could tear it to the ground and build a parking garage. So that none of these functions that are being performed by Stadco are governmental functions that the GWCCA would otherwise have to provide. And that is the basis for Stadco's argument that these are not public records and that it is not subject to the Open Records Act. Mr. Kendall's allegation that Statco is the alter ego of the GWCCA is completely unfounded, and there's absolutely no evidence in the record to support such an allegation. That is a term of art And under Georgia law, for a company to be an alter ego of another company, there has to be a commingling of funds, of use of a corporate form. There's not even an allegation of that, much less any evidence in the record.
Well, and I'm going to stop you for a sec. I didn't take Mr. Kendall to be making the legal argument that it was an alter ego, and he can correct me if I'm wrong. That's not in his briefs. I think it was an evocative way of describing, and it fits with the chart he put together. You know, it's in the past, GWCCA did A, B, C, D, E, F, G, H, and onward at the Georgia Dome. Georgia Dome's gone. Literally next door is a new stadium. And who's doing all those things? Well, it's not GWCCA anymore. It's Stadco, ostensibly doing those things on behalf of the GWCCA. Hence the argument we're having. So I wasn't persuaded that maybe there is this now private version of GWCCA that's legally the alter ego. I just thought that was a good way of describing the similarity of roles. If you took a snapshot when the Falcons were at the Georgia Dome, and now you take a snapshot of the Falcons being in Mercedes-Benz.
And I do think it is also very important to point out that even in Northside, where the court found that there would be some documents that would be public records, such as the lease. They said, the lease would be a public record. But with respect to the documents that were actually being sought in Northside, the documents related to the 4 acquisitions by Northside, the court did not find that those were public records. The court did not order Northside to turn any of those documents over in that case, which that holding in and of itself is an opposite to the position that Mr. Kendall has taken. According to Mr. Kendall,
I need to stop you for a minute, Mr. Hendrick. Your sound is a little choppy. Ms. Crump, I can understand what Mr. Hendrick is saying. More important, are you able to take down what Mr. Hendrick is saying? Because I think Mr. Highsmith, in an effort to get to talk, has sabotaged Mr. Hendrick's audio feed. But Ms. Crump, are you able to follow what Mr. Hendrick is saying?
Yes, sir, I have so far, but it, like, as you said, it is a little choppy. So maybe Mr. Hendrick, just slow down a little bit. I don't know why your audio is chopping like that. Maybe because you're on a separate.
Yeah, it's digitizing a little bit. You sound like a little robotic.
And I will say, I don't know if everybody is experiencing this, but Judge McBurney, when you were just speaking, and also
I'm sorry, I'm not getting that.
I can't hear it either.
Okay.
Judge, I will deny any allegations of sabotage, but while Mr. Hendrick straightens out his audio, I'll just step in briefly and say that we actually were counsel in the Northside case. We replaced Randy Evans shortly after the Supreme Court ruled in 2017. And exactly as Mr. Hendrick was starting to say, the records sought in that case were records relating to the acquisition of physician practices, not the operation of the hospital. And so had that case proceeded, that was going to be a hot argument. Does the acquisition by Northside, a nonprofit, of physician practices, is that something that the hospital authority is required to do? We would have argued clearly not, and that those records would not have been subject to the act. Very similar analysis here. Quite tellingly, Your Honor, when that case finally wound its way back to your court,
So we're clear, Judge Tucson, not Judge McBurney.
Not to the Fulton County Superior Court. Yes, right. Your Honor. That's all I meant by your court. When it wound its way back to the Fulton County Superior Court, John had retired and Judge Carnesale had been appointed. And in that case's first appearance before the trial court after the Supreme Court's decision in Northside that we've been discussing, Jones Day dismissed the case altogether. Now, you can call them up and ask them why they did that, but our strong suspicion is that they couldn't meet the standard to get those records because the acquisition of those physician practices was nothing that the charging statute in Northside required them to do. Similarly here, as Mr. Hendrick was saying before his audio deteriorated, if Atlanta didn't have an NFL team, the World Congress Center Authority might turn its attention to hockey or a parking deck or curling. There's no requirement in that statute that the World Congress Center operate an NFL arena. And because of that, and because of the binding interpretation in the Northside case, the leanings that Your Honor expressed at the beginning of this hearing are absolutely correct, that those functions are not on behalf of the GWCCA as the Supreme Court has interpreted it, and these records are therefore not subject to the Act.
They are on behalf of, but not in the sense that the Supreme Court has said those three words are to be applied in the Open Records Act.
Precisely, Your Honor. And of course, we're all bound here to follow that precedent announced by Justice Peterson, who, as Mr. Hendrick quite rightly reminds us, the history, he was also the principal drafter of those revisions when he was the Solicitor General of the state in 2011 and 2012.
Okay.
Judge,
Mr. Hendrick, I'll turn to you, Mr. Kendall. I promise. I'm going to circle back with you on the Northside thing. Then I want to get to trade secrets. And then if there's anything else you guys want to cover, we'll do that. But Mr. Hendrick has plugged back in, I think. Try saying something, Mr. Hendrick. Can't hear you. I did add your phone again, but it disappeared. So what I'm going to do is this. You work on the tech side. And Mr. Kendall, I want to give you an opportunity to say anything in response to what counsel for Stadco, the two lawyers, have just articulated as to what Northside means and how it should be applied. And don't be too troubled about speculation as to why Jones Day dismissed. I mean, to me, that's historically of interest. It doesn't have anything to do with how we ought to work through this matter, but it sort of puts that final punctuation mark on the saga that is Northside. Before you talk, Mr. Kendall, there. All right. I muted Mr. Hendrick's phone that was creating the loop. What did you want to say in response, Mr. Kendall?
I wanted to say this. If we take Stadco's argument out to its, what I would call its illogical conclusion, then any public agency would be able to say that, let's take, for example, in the city of Atlanta, they have a development authority called Invest Atlanta. They could say, we don't have to have Invest Atlanta. It's not something that we have to have. So therefore, all of their records are not subject to the Open Records Act because we don't have to have an Invest Atlanta. We don't have to have a Parks and Recreation Department. So all of the records of the Parks and Recreation Department are not subject to the Open Records Act. Now I'm assuming that, of course, they decided to farm that out to a private entity. Of course, that's the operative word here. They decided to contract all parks and recreation activities out, as they have done with several of the golf courses. Municipal golf courses in the city of Atlanta are operated by a private entity. So the city could, under their theory of what the Open Record Act covers, say that all of the records with regards to golf courses in the city of Atlanta are no longer subject to the Open Records Act, because the city is not required to have a golf course.
I'm following you, but isn't the more precise way of putting it would be the records in the possession of the private entity operating the golf course? If the city had records, they'd have to hand them over.
That's
because they're
correct.
in the possession of an agency. So,
You're right. You're right.
Okay.
And with that caveat, yes. If some private citizen said, well, we want to know exactly how much revenue is being taken in by these private companies that are handling the city's golf courses, to see if the city is getting a good deal and whether the taxpayers are getting a good deal from the city having contracted out these golf courses, then those golf courses wouldn't have to give over that information, because they could easily say, we don't perform a function or service that had to be performed by the city of Atlanta. So you would be eviscerating the Open Records Act in subsection B2 by virtue of the have to language. And I don't think the Northside case was that precise or intended that limitation or restriction on that language, which is half of what that sentence says that you quoted.
okay. Got it. So let's talk a little bit about trade secrets. And I'm going to flip the order of presentation, and I'd like to hear from Stadco's counsel on this. And two areas. One, why wasn't the trade secret exemption claim waived? Because it wasn't set forth in those first 3 days by Stadco. They simply said, we're not subject to Open Records Act. And then two, if you could address the argument that Mr. Kendall raised that to qualify as a trade secret, there ought to be some articulable value to the sensitive information. I think you've satisfied, were there steps taken to keep it secret? I think that the affidavit from, I think the name was McCabe, but the gentleman who was an executive at Bank of America made pretty clear that all sorts of steps are taken to keep that which was redacted out of public eye. I guess the third question, Mr. Kendall flagged in his brief the fact that a whole lot of what was going on was the subject of public debate at public hearings, and that a number of records were made part of the public record at the public hearings. I assume if the exact redacted pages were included in the public records, we wouldn't be doing this weird circle dance, because then his clients would have them. But just address the argument that Mr. Kendall made that basically enough was revealed that there couldn't be this urgency and need for secrecy. And we'll try you again, Mr. Hendrick, but if it doesn't work sort of up front, then the saboteur will get to go. I can't, you're not muted, but I don't hear anything.
I think it might be. Andre, what I'll suggest that you do is just turn off your computer altogether and only dial in using the dial in from your phone. We won't be able to see you, which will be disappointing, but we will in that way be able to hear you. Your Honor, in the meantime, I'll address the questions that you've posed. First of all, yes, the Open Records Act reaches private companies that are working on behalf of a government agency. There's no dispute about that. The provisions, though, that state that an exemption is lost if you don't assert it immediately can't apply. It's impossible to apply them to a private entity in the same way that you would apply that provision to a government. If in Mr. Kendall's example, you asked for records from the Parks and Rec Department, the Parks and Rec Department didn't give them over and didn't cite a proper exemption, then the act is very clear that Mr. Kendall gets the records, he gets attorney's fees, and the agency is stopped from later asserting an exception. For a private entity, it's very different. When Bank of America, for example, submitted financing information to the government, why would that to the Falcons, to Statco? How on earth would they have gone through the process
transmitting to the government what those trade secret documents are. 72A34 requires someone who is required to submit to an agency, not to a private entity, but someone who's submit to an agency their trade secret information. They have to attach an affidavit. The affidavit has to contain these various representations that are set forth in 72A34. That doesn't apply here because Bank of America didn't provide that information to the authority. They provided it to their customer, Stadco. So years passed, and Mr. Kendall develops an interest in these documents that were never in the possession of the government, and states that he's entitled to them under this theory that he's advancing here. In the meantime, the Northside case is decided after all of this has taken place, after these documents had been submitted, and Bank of America and Stadco quite appropriately said, hold on a second, if we're going to have to hand these things over under this new approach, we're going to have to be allowed to assert the trade secret exception. And the trade secret exception, Your Honor, applies. The Trade Secrets Act over in Title 10 protects the trade secrets of Bank of America and Stadco separately from the protections that the Open Records Act affords. And we submit that the Open Records Act provisions, the Open Records Act provisions that prescribe how one establishes the trade secret exception can't apply to someone who is submitting trade secret information not to a government agency, but to a private entity working for a government agency. There'd be no reason for Bank of America to have executed an affidavit then when giving that information to GWCCA. As for the substance of the trade secret.
Let me pause you for a second
Sure.
to try to process what you were saying. So if we rewind a decade or more, and it's the Georgia Dome, and it was Chase that provided the financing, I'm making this up, for the Georgia Dome, there's no Stadco there, it's GWCCA. And so the financing documents that Chase is preparing that may well contain sensitive, proprietary, call it trade secret information, you're saying because that is being provided to an agency, that there is a different obligation on Chase when it says, here's the lending proposal, this is our bid, this is how we want to be your financier. There's a different set of requirements on how those documents are handled than Bank of America and Stadco private. Or did I misunderstand what you were saying?
Procedurally, absolutely, Your Honor, because A34 is very clear on what a private entity has to do when it is required to submit documents to an agency. That's what 72A34 says. They have to attach them to an affidavit, and then there's all this procedure if someone wants them. But when the documents from Bank of America are submitted not to an agency but to a private entity, Stadco, none of that applies. And the question only then becomes, does the substance of the Trade Secrets Act over in Title 10 protect these records? And we think that that's pretty open and shut that they do. I mean, the definition of trade secret in Title 10 is extraordinarily broad, appropriately so. So that, persons that are doing business with those doing business with the government don't have to fear that their information will be, their pricing, their interest rates, their loan doc, other aspects of their loan documents won't become inadvertently public because they didn't foresee an open records request to Stadco. Now, had they submitted this information directly to GWCCA, as Your Honor points out, very different. They either complied with A34 or they didn't.
So practitioners in public finance, meaning lenders who might be providing finance for an agency, a public agency, they know that in submitting things that they think ought to be protected, when they are provided to the agency, accompanying the sensitive information is something that flags it as such, which would then trigger the A34 protection. That's just how that would work in common practice.
private entities that are required to submit information to the government, whether it's building plans or patented technical information, pricing, financing terms. Happens all the time that they simply comply with the provisions of the A34. And then if the agency later determines that the private entity overreached, there's a very specific procedure in A34 to litigate the substance of whether those materials are protected.
Okay.
And Your Honor,
Your Honor,
we have Andre back. I'm going to hand the ball back to him.
All right.
Because the issues that Mr. Highsmith was just discussing really raises a couple of different topics and issues. Number one, in the United Healthcare case, it addresses a situation similar to what we have here. There is a discussion within that case where the court addresses instances where there are documents that have been sought under the Georgia Open Records Act that were never submitted to an agency. And in some of his briefing, Mr. Kendall actually takes the position that these documents, and we haven't really talked about exactly what we're talking about. What we're talking about here are private loan documents between Bank of America and between Stadco. This is not a document that the GWCCA was ever a party to. So we're talking about private loan documents between Stadco and its lender. Okay, and Mr. Kendall states several times in his briefs, and we agree with him, that these documents were never provided to the GWCCA or any of the other agencies to which Mr. Kendall submitted a GORA request. And so United Healthcare discusses this particular situation. And one of the arguments that Mr. Kendall asserts in his briefs is that these documents, these finance documents, cannot be trade secrets or cannot contain trade secrets because they were not submitted to an agency. And that argument was directly addressed by United Healthcare and rejected. In fact, the court said in United Healthcare that adopting such a position would lead to an absurd result, that being that documents that were never provided to a government entity that contained trade secrets would be afforded less protection than if they had been shared with a government entity. And they said that that would be an absurd conclusion. And so the court goes on to say that in such a situation where documents have not been provided to a government agency, then you look to Title 10 to determine whether or not they are entitled to trade secret protection. And so you're back to this two-prong approach. Is there economic value, and have reasonable steps been taken to maintain their secrecy? And there is an undisputed affidavit by Mr. McCabe, a Bank of America representative, that has gone through and explained exactly why there is economic value from this information that has been redacted and the steps that they go through to maintain secrecy. There's also evidence in the record that these same documents were protected by Stadco by forcing their employees to enter into non-disclosure confidentiality agreements. And so the mere fact that these have not been provided to a government agency has no real bearing on whether or not these are trade secrets. But Robert's point is well taken, and that is in a traditional context. I work on a lot of bid protest cases dealing with managed care. So does Mr. Highsmith. And so when these bid proposals are submitted to government agencies, information within them is frequently redacted because it contains trade secrets. And that way you are informing the governmental entity, we understand that you're subject to the Open Records Act request. If anybody requests these documents, here is the information that we consider to be secret. And that kind of brings up another issue that Mr. Kendall has raised in his briefs. He alleges that there are numerous agreements which he attached to his pleadings in which Stadco acknowledges that it is subject to the Open Records Act request. And that's absolutely not what these documents say. In fact, if you look at the documents he cites and the sections within those agreements, in context, that these agreements actually support the point that Mr. Highsmith and I are now making. And what it says is that Stato acknowledges that it's going to be doing business with governmental entities that are subject to the Open Records Act request, and that they need to familiarize themselves with the Open Records Act because documents that they exchange and provide to those entities may become subject to a request. And so that they need to be cognizant of it, e.g. they need to inform these entities if they are providing any information to these entities that they consider to be trade secrets, so that they would be withheld and not disclosed.
What about the claim that in a public setting, much of the financial information was either discussed or at least made available? I assume it wasn't verbatim the redacted pages, but one of the arguments Mr. Kendall made suggesting that Stadco and or Bank of America hadn't really worked all that hard to keep the financial information secret was purported discussions or documents at public proceedings.
And Your Honor, I think that argument is really untenable. It's a red herring. Everybody knows that whenever I think about trade secrets, I always think about the formula for Coke and how Coca-Cola would guard that with its, life. And, Coca-Cola has press conferences all the time. They disclose all sorts of information. They talk about their product all the time. But you're never going to find anybody at Coke stand up at a press conference and say, here's our formula. And the fact that they talk about it and their product and all sorts of other information doesn't change the fact that they don't disclose the formula.
I get
and
that.
Here,
what you're saying is there was not a public disclosure of that which was redacted.
No. And what we're talking about here, Bank of America is operating in a very niche environment. They are lending in the space of private sports arenas. Okay, excuse me, not private, but professional sports arenas. There aren't a lot of those in the United States. This isn't a big market. And Bank of America believes that it has come up with a way to structure its deals that gives it a competitive advantage. And they've spent a lot of time and resources creating these contractual documents, these contractual provisions that they consider to have economic value.
Okay, and I appreciate that. And the nature and structure of those will be far beyond my level of understanding. But what you're saying in response to my question is that at no point that you're aware of at a public proceeding was the secret recipe for professional sports arena financing that Bank of America has developed shared.
Correct.
Okay, it may have been a discussion that we got an attractive lending rate, or we're happy working hand in hand with Bank of America that has structured this in a manner that is good for the people of Atlanta or whatnot. But it wasn't, they're using a reverse leverage mortgage or anything like that at 2.1%. The specifics of the financial recipe, you are saying in response to Mr. Kendall's allegation that basically we were able to look under the tent anyway at a public proceeding. It wasn't the specifics. It was your Coca-Cola press conference where they're talking about what a great product Coke is, but they don't mention that nutmeg is the special ingredient.
Exactly. And based on my discussions with Bank of America, the information that was redacted has not been publicly disclosed at the press conferences or articles cited by Mr. Kendall or otherwise.
Okay. All right. Anything else you want to add, Mr. Hendrick, on the trade secrets? Because I'd like to hear from Mr. Kendall on trade secrets.
Not in response to the questions you've asked. We may want to respond to some of what Mr. Kendall says, but at this point, I think that's everything.
Okay. Mr. Kendall, trade secrets, your thoughts?
Well, several. Whether we go under the trade secret exemption in the Open Records Act, or we look at the trade secret statute under Title 10, these particular documents that are claimed to be trade secrets fit neither definition. If we look at the trade secrets provision of Title 10, there are basically two things that are required in order to make an item a trade secret. And that is that it has some secret some particular economic value that's not readily known by the public. And I think the specific language of the statute there is derived economic value, actual or potential, from not being generally known to or not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure. And then that there have to be efforts to maintain the secrecy of that information. Now, as to—
So before you go further, I don't disagree with anything you've said. The procedural posture we're in right now is summary judgment, and you want summary judgment on the question of it couldn't possibly be trade secrets.
Right.
Aren't there issues of material fact based on the definition you just provided? You disagree with how Stadco has characterized, and we can say how Bank of America has characterized because we have the affidavit. You disagree with it, but isn't that disagreement one that would require a fact finder to resolve it as opposed to it being purely a question of law?
Okay, well, let me be clear about this. This definition that I just gave would have to apply to Stadco. Bank of America is not a party to this action. And I don't think it's proper for Stadco to try to claim a trade secret on behalf of some third party, i.e. Bank of America. So we're talking about whether or not this information has economic value, actual or potential, to Stadco, and whether or not Stadco took efforts to maintain its secrecy, not Bank of America, because Bank of America is not before the court. Now, this same type of information has been ruled not to constitute a trade secret in the case of the Tollway Authority versus, and I'm trying to find that case. Here it is, State Road and Tollway Authority versus Electric Transaction Consultants Corporation. That's at 306 Georgia Appeals, 487, cited in my brief, on my summary judgment brief on page 21. In that case, the defendant, Electrical Transaction Consultants Corp., claimed that they had detailed technical and pricing information that was proprietary and confidential. The court ruled that the information, the detailed pricing information, and its unredacted price proposal was not a trade secret. And that's no different than what we have here. Stadco, on behalf of Bank of America, again, that's a defect in their argument, in my opinion. But assuming that Bank of America was before the court and they were claiming a trade secret on this information, this particular case, State Roadway and Tollway Authority, pretty much knocks that argument in the head. And then when we go further and look at the fact that it could not possibly have any economic value at this particular point in time, even if it had some economic value at the time that information was created. Here we are now 7 years later from 2013 when that information was originally created. So any pricing information, any interest rate information, any terms, et cetera, that were relevant in 2013 are certainly not relevant in today's financial economic market. So there's a time differential And then we talked about particular stadiums. Well, obviously this information would have only applied to this particular borrower for this particular stadium at this particular geographic location. So it's unlikely that what was potentially secret at the time it was given in 2013 for the Atlanta Falcons for the Mercedes-Benz Stadium in Atlanta, Georgia, has no economic value whatsoever to the Oakland Raiders who are building a stadium in Las Vegas, Nevada in 2020. So this information could not possibly have any economic value today concerning the construction of the Mercedes-Benz Stadium in 2013 and 2014. So it does not fit the definition given to us by Title 10 for a trade secret. And for that same reason, and for the additional reason that this argument was never made in the beginning, in the 3 days, it doesn't fit the definition of a trade secret under the Open Records Act. Now, Mr. Highsmith said that, well, you can't apply the same standard to a private entity that you would apply to an entity that was giving trade secret information directly to a public agency. Well, the statute makes no distinction. We can't engraft terms into the statute that the legislature did not find to be the case when they drafted the statute. So if we engraft a new requirement that this exemption only applies to public agencies and not to covered private entities under B2, then we are essentially rewriting the statute. My position is that the case of the trade secret argument is covered by the Tollway Authority case.
Okay.
Your Honor, there were several very, I would see them as discrete points that were raised by Mr. Kendall, and I think I can address them in order and succinctly. If
The
that's okay.
main one I want you to address is Mr. Kendall's reorientation of the focus. When I was engaging you and Mr. Highsmith, it was Bank of America, Bank of America, Bank of America. Mr. Kendall has said, it's fascinating what Bank of America wants. That's not who we asked to provide any information. We want what Stadco has. And how could this be a trade secret of Stadco's? It's not a financier. They're in possession of the document. And if one were to find that Stadco was doing work on behalf of a public agency as on behalf of is meant to be applied in the Open Records Act, shouldn't that be handed over? Because there's no economic value to Stadco for the financial information in that document. It's the value and the trade secret moniker that we'd place on it would be on Bank of America's behalf, and they're not a party to this. What was wrong with focusing on the parties to the litigation?
Okay, Stadco does disagree with Mr. Kendall's position. I'd like to point out that Mr. Kendall has not cited to a single case that addresses this issue within the context of Agora request. We believe that the case of Georgia Department of Natural Resources versus Theragenics Corporation should control the court's inquiry on this point. That case can be found at 273 Georgia 724 2001. In that case, you had the Georgia Supreme Court discussing the obligations of a state agency when it receives a Agora request. And the Georgia Supreme Court said that a state agency has an obligation to review the documents before it produces them and withhold any documents that are subject to exceptions, statutory exceptions. And in that case, they were specifically talking about trade secrets. So in that case, you would have the Supreme Court was telling a government agency, if you receive a Agora request, you have to assert the trade secrets exception on behalf of the third party private entity that provided that information for you. And that rule should apply in this case just as much as it does there, where Stadco is receiving a request just like the Georgia Department of Natural Resources in that case, and Stadco looks at the documents that were requested, and they have said, these documents are from Bank of America. We're going to reach out to Bank of America, and we're going to say, are you okay with us producing them? And Bank of America says, no, these documents contain trade secrets. And so Stadco, much like the Department of Natural Resources in the case I just cited, redacted them, asserted that privilege on behalf of the party who owns the information, not the party who received the request, and produced them in a redacted form. And so this issue has been addressed by the Georgia Supreme Court, and that there's no reason why it would not hold true in this context, just because the request was made to Stadco as opposed to a government agency.
Okay. Another point Mr. Kendall made, I think, is more applicable to the construction contract, and maybe why ultimately Stadco removed the redactions from the construction contract, because it is a unique stadium and it was built a while ago, and whatever magical terms were in there may have lost some of their luster and their economic value. To me, it would be a factual issue that would need to be decided by the fact finder at trial, whether there remains economic value in the materials that were economic value to Bank of America in the materials that were redacted. I don't know that the mere passage of time would deplete that information of its economic value if there is a financing structure that could be used today. And I guess it would become a question of fact as to whether that financing structure could apply to stadia built elsewhere, whether it's the Southeast or it's somewhere else in the US, and on what scale. But you're welcome to say something about that if you want, but I fall back on, I appreciate both sides' perspectives, but that's a pretty intensive fact inquiry as to whether there's still economic value, even though the lending proposal was presented a few years ago.
Your Honor, I would like to address that, because during in a specific and a general sense, when you were discussing with Mr. Kendall, you talked about, and you raised the question, well, isn't that a disputed issue of material fact? And the fact of the matter is that Mr. Kendall has not introduced any admissible evidence in the record regarding whether or not there is economic value, or whether or not Bank of America took reasonable steps to maintain those secrets. On our standpoint, from Stadco, we have introduced an affidavit from Bank of America, and we have introduced an affidavit from Stadco establishing those points. Mr. Kendall did not depose anyone from Stadco or Bank of America. He has not provided any affidavits into the record. In fact, he has introduced absolutely no evidence to rebut the evidence that we have introduced establishing that this is a trade secret. The only thing Mr. Kendall has done today is argue. An argument is not evidence. And the case that he cited, that the tollway authority case that he said knocks it right on the head or knocks it out, if you actually dig into that case, you see that it is completely inapplicable. The court did not find that there could not be a trade secret because of the nature of the information or because it was a contract. The court found that there was a failure to present evidence to the court upon which a finding of trade secrets could properly be based. The court said because there was no evidence to support the judgment, the trial court manifestly abused its discretion in enjoining the authority from opening the documents to inspection. The court said on this record, Electronic failed to support its contention that its detailed price proposal contains trade secrets. It did not submit any affidavits. The appellate court said there was no competent evidence before the court via affidavit establishing the claim of trade secret. And that's not the case we have here. There
So
is
remind me,
competent evidence.
I'm following what you're saying. And I think that my recollection of the affidavits as to steps taken to maintain secrecy, they were more than sufficient to establish that. Remind me what is out there as to the economic value, because what's sticking in my mind is Mr. Kendall's observation that in response to interrogatories, Stadco said, sure seems like that would be valuable information. My words, not his, and certainly not Stadco's, but the synthesis that I got from it was that Stadco's response to the interrogatory of, well, what is the economic value of the redacted information from Bank of America was, well, you know, it seems like it's valuable. And presumably something more needs to be there. And I have McCabe's affidavit here and I can pull it out, but I want to give you a chance to articulate it as the way in what you think is the most effective way.
Well, paragraph 8 of McCabe's affidavit goes directly to that point. And he says the redacted information in the lending agreement is considered trade secret information by Bank of America and includes confidential pricing information and contract language that was developed internally by Bank of America, which reflects Bank of America's institutional expertise in structuring and administering a complex system of sources, use, and funding for stadium construction credit facilities, which is unique to the stadium construction lending industry.
Okay,
Bank of
I see it.
America relies.
And the final sentence is that Bank of America derives considerable economic value from maintaining the confidential and secret nature of the redacted information. And your point is there's nothing in the record before me beyond Mr. Kendall disagreeing with that averral to suggest otherwise.
Correct.
Okay.
Except for their own interrogatory responses where they were not able to identify what economic value this information had.
Okay, and I'm remembering that. That's what triggered the question. So
yes, the question was asked
Kendall
specifically.
asked us to evaluate it as if we had gone and had a third party appraise and assign a specific value amount to this, and we've briefed it, and there are even cases on point which are cited in our brief that unequivocally state that that is not required. Okay.
I got that. Mr. Kendall, what do you want, anything you want to say, summing up your view beyond what you've already shared with the trade secret part?
Right. To Mr. Hendrick's point about evidence, an affidavit of Mr. McCabe where he just simply says that it's his opinion that there's economic value to this information is not evidence. It's just his opinion. And as I stated, I requested what information they had which showed that this information had some economic value. And there was no response to that inquiry. Also, I want to point out to the court the case of Campaign for Accountability versus Consumer Credit Research Foundation, which was decided by the Georgia Supreme Court in 2018. And the site on that case is 303 Georgia 828, which basically says that, if I recall correctly, that an agency who is requested to provide information that some third party might think is confidential is under no obligation to protect that information on behalf of the third party.
Okay. So I should read that alongside the Theragenics case.
Yes, sir.
Okay.
Your Honor, earlier you mentioned that you would want us to discuss the two cases that Mr. Kendall cites in support of his waiver argument. with respect to trade secrets. I don't think we've done that. Do you still have any questions about that?
Well, I did ask that, and then as both sides were presenting to me, it made me wonder if the distinction there was that Chua and in those two cases, the information had been provided directly to the public agency. So this was getting to Mr. Highsmith's point about the difference between one private entity providing it to another, and then the ORA request comes to that private entity. Query, are they subject to the ORA? And I just don't remember with Chua. I think Chua, there was a DA's office or something, or law enforcement. But if those two, the request was to a public agency, and the public agency in responding didn't invoke one of the exemptions within those first 3 days, and so they were waived. And if that's the set of facts in those two cases, I think they are distinguishable from this case. If that's not the set of facts, then you should tell me why you think those two cases don't apply here.
Well, I think there is one thing to add, and it's the statute that governs OCGA section 50-18-72B34 provides that in any instance in which an agency is required to or has decided to withhold all or part of a requested record, the agency shall notify the requester of the specific legal authority exempting the requested record or records. So in that particular statute, which is what Mr. Kendall is relying on, the statute says specifically the agency, not the party to whom the Open Records Act was submitted. And just a minute ago, Mr. Kendall said that we can't engraft terms onto the statute. You have to look to the terms of the statute, and that is exactly the argument that I would make here. When you look at the terms of the statute, the legislature chose to say the agency, not the party who received it.
And that was 70, well, give me the statute again, please.
Yes, Your Honor. It's OCGA section 50-18-72B34. And in both of those cases that were cited, Chua and City of Marietta, one, the request was made to the DA's office, and in the other one, the request was made to the City of Marietta. And so in both of those cases, the request was made to the agency. And so the court said, under the statute, you're an agency, you had to assert any exemptions within that 3-day period. Mr. Kendall has not cited to, and we have not found any cases that apply that statute, that 3-day waiver requirement, to a private entity that has received a GORA request.
So there's
Your Honor,
no B34.
It's
There's just
A34.
A34.
A34, Your Honor.
Okay,
Apologies, that must have been a typo.
that's all right. I just want to make sure I'm looking at the right thing. So it's the A34 we've been talking about. It's a long paragraph, but that's what was at play. Okay. The last thing that I would like to hear about, because of questions that came up for me in reviewing all the briefs, is what I'll say in just a minute. But again, if there are additional things either side wants to cover before we wrap up, I'm open to that. And it has to do with attorney's fees. And it's a question for Stadco, but I'll certainly hear from Mr. Kendall on it if he wants to add anything. Do you agree that if the ultimate finding is that Stadco is subject to the ORA because of the work it was doing on behalf of GWCCA, that even though documents were ultimately provided, and let's set aside the trade secret piece. Let's say I find it is a trade secret. So basically you've complied with the ORA now. There was still a period during which Mr. Kendall had to advocate on behalf of his clients to ultimately get those records. And so under the Title 50 attorney's fees claim, there ought to be some attorney's fees that are recoverable. was a lot of words. I'll try simplifying
Yes,
it.
no, Your Honor,
You got it?
I completely understand what you are asking, and we would disagree that plaintiffs are entitled to recover any attorney's fees. There is a requirement in OCGA section 50-18-73B that imposes a acted without substantial justification standard, and the court has to look at the record on the whole. And in the GMS Air Conditioning Inc. versus Department of Human Resources case, which can be found at 201 Georgia App 136, it's a 1991 case. The court said where evidence on summary judgment is ambiguous or doubtful, the party opposing the motion must be given the benefit of all reasonable doubts and of all favorable inferences in such evidence construed most favorably to the party opposing the motion. And Your Honor, what we have here is one case handed down by the Georgia Supreme Court, the Northside case, which arguably is guiding this court's inquiry. And even the court today during the call has had some questions about the meaning of some of the language in that holding, and both sides have strongly disagreed on how that would otherwise have to perform language applies in this situation. And from Stadco's position, that case means what the case means. And Stadco is not performing a governmental function that the GWCCA would otherwise have to perform, i.e., if the Falcons move to another state, the GWCCA would not have to continue to operate or maintain an NFL stadium. And if they knocked Mercedes-Benz Stadium down, the GWCCA would be under no obligation to rebuild it. And we believe that that is a tenable position that is rooted in the language of a Georgia Supreme Court case that was only issued a couple of years ago, and that frankly has not really been fleshed out since then in this particular context.
Well,
and therefore
sounds like this
Stadco
case
has,
flesh it out.
Based on that, Stadco had substantial justification in this position. And that is a burden that Mr. Kendall and plaintiffs have to overcome in order to receive attorney's fees. They have to establish that our position was without substantial justification. And given the current flux in the law, they can't do that.
So not to put too fine a point on it, but your client said no to Mr. Kendall's ORA request one day after it was made, but about a month before the Northside opinion came to exist. So is there an argument to be made that at a minimum, it wasn't substantially justified until the Supreme Court had spoken, or the Supreme Court were merely espousing what the law was and had been, and so that sort of grandfathers in Stadco's polite declination of the request to produce that occurred, as I mentioned, 3 or 4 weeks before Northside was issued?
Your Honor, I do not believe so. If you look at the cases before Northside, there aren't a ton of cases that are addressing this narrow inquiry, which is the obligation of a private entity to produce documents in response to an Open Records Act request. And when you review those cases that preceded Northside, there's not really a bright line rule given. Some cases look at some factors, some cases look at some other factors. And so it's not like it has been interpreted to say, this is what it means. Really, that's what Northside did. And so I think an argument could be made that when the response letter was sent by Stadco, that they were substantially justified in thinking so. In fact, to a lot of entities, I can tell you that they saw the Northside case as being a little scary because it was imposing obligations on private entities that those entities did not think had previously existed. That this has not been a terribly clear area of the law. And so, no, I do not think Stadco was statute's position lacks substantial justification.
Okay.
Judge, if I, given the weightiness of that question, if I might add to what Mr. Hendricks said with the court's permission.
Sure.
The statute says that an agency shall have 3 days. Statute says an agency shall have 3 days. And the definition of agency does not include a private corporation doing anything on behalf of an agency. The definition of public record includes records that may be held by a private entity doing things on behalf of an agency. And we're certainly not arguing that in an appropriate case, a private entity is subject to the Open Records Act. We all acknowledge that. But the 3-day requirement that Mr. Kendall keeps harping on is applicable only to agencies. Nonetheless, and this is the second thing I want to point out, the general counsel to Stadco, who did respond within 1 day, stated the position of Stadco that remains the position of Stadco. The provision, we're not going to get into discussion of settlement talks or other conversations we've had with Mr. Kendall and his clients, but I want to be very clear that the submission of the documents to Mr. Kendall that Stadco did make were not a concession to the merits of his legal position, but were rather an attempts to avoid what we're doing here, which is litigating the issue, and that's why we redacted only what we redacted. But the position of Stadco was and remains that it is not subject to the Open Records Act, and absent a finding by this court that position lacked substantial justification, was somehow completely inappropriate, no legal basis for it, then any discussion of an award of attorney's fees, in this case, Your Honor, we submit is entirely inappropriate.
Okay. Thank you for adding that. Mr. Kendall, your thoughts on the Title 50 attorney's fees question?
Yes, Your Honor, I think it's pretty much without question that if a party does not respond within the 3-day time frame, that party is obligated to pay attorney's fees.
Do you have a case that I'm pressing there only because
yes,
Mr. Highsmith, of course, is correct that it says the agency shall have 3 days. That creates a big loophole for a scenario like yours where, or in Northside, where it's not the agency, it's the private entity that has been contracted to do the public agency's work.
There are 2 questions there. The first question is about a case on the attorney's fees, and the City of Marietta versus Jersey versus City of Marietta case, I think, speaks to that. Also, the case of Benefit Support Inc. versus Hall, 2006 case both cases are cited in my brief on page 26. Speak to that issue of attorney's fees anytime there is a lack of substantial justification for the violation.
But that okay, I don't disagree with you there. If there is not substantial justification, the statute says you ought to get attorney's fees. So right. I probably made my question more complicated than it needed to be. You started out by saying, no, Judge, any recipient of an open records request has 3 days to respond, not just an agency. And I said, the statute says agency. Is there a case out there that says, well, agency means anyone?
No, I haven't particularly looked at that specific question, but I think the language is generally that if there is no substantial justification, and in this case, I don't think there was any substantial justification for the position that Stadco took, that they were not subject to the Open Records Act. That was their position. And as you pointed out, that position was maintained even before the Northside case, which Mr. Hendricks said was a justification, was the Northside case, but the position was taken before the Northside case was ever decided. Now, I don't know if they were channeling the Supreme Court's opinion, but those are the facts. So I don't think there was any substantial justification, and the law was clear prior to Northside as I previously indicated in the Hackworth decision, that when a party is hired and performs services or functions in the operations of a public office or agency, then that private party is subject to the Open Records Act. That was a case from 1994. So it was pretty clear from that case and others that I also cite on page 6 of my brief for summary judgment, that private entities are without question subject to the Open Records Act if they perform for services or functions. Now, they've seized on this have to language in half of the quote that you indicated from Northside, but that didn't come about until after they had denied that they were subject to the Open Records Act. So if we assume that the law was Hackworth and its progeny prior to Northside, then it was pretty clear. And some of those other cases were Macon Telegraph Publications Company versus Board of Regents of Georgia, Clayton County Hospital Authority versus Webb, etc. These cases made it clear that private entities were subject to the Open Records Act if they performed services or functions in the operation of a public office or agency. And as Mr. Highsmith just said, the definition of public records is inclusive of an agency, of a private entity and an agency. So I don't think that at the time that their general counsel for Statco sent me his letter absolutely refusing to provide any records on the theory that Statco was not a public agency, was a position that was supported by the law at that time. Even if you assume that it became a gray area, which we dispute, after Northside. And then even after Northside, of course, we were able to obtain some of the records that we requested. And I'm not saying that they agreed to or ceded to our positions in any of this, but irrespective of the fact that they later, so to speak, saw the light and gave up some of the records and are now just claiming a trade secret on behalf of a third party who is not before the court, I think that position is not substantially justified. Because how can they, in this litigation, claim an exemption on behalf of a third party who is not before the court?
Got it. Those were the areas that I most needed input from the two sides. Mr. Kendall, were there other aspects of your motion for summary judgment or the cross motion from Stadco that you wanted to cover today?
Judge, as I stated when I got on this call, I really wasn't prepared to go forward with this because I just didn't read carefully enough to notice. But I have nothing else to add to this, and I'm glad you indulged me, and I apologize for being late to the call.
Not a problem. We appreciate you connecting on ultimately short notice. We tried to get you more advanced notice. Mr. Hendrick, Mr. Highsmith, anything else?
Your Honor, I'll let Mr. Hendrick sum up briefly if we need to, but I just want to address one thing that Your Honor said in response to my pointing out that the definition of agency doesn't include a private entity, but the definition of public record does. Your Honor called it a loophole. I know you didn't. I know the court didn't really mean anything pejorative by that, but let me explain why the legislature actually was quite wise in not imposing the 3-day requirement on private entities holding records that are arguably public records. And not to belabor too much the Northside case, but that case was pending before the trial court for quite some time, days of hearings over whether the records met the test or not. Back up to the Supreme Court, where the Supreme Court rejected the position of both parties and said, here's the standard, now go back trial court and apply the standard to all these records. For public records in the hands of an agency, it ought to be easy. Public ought to be able to come in and say, look, give me this stuff in 3 days. If there's an exception, cite it. If there's not an exception, give me the records. And if you don't, there are consequences. Fine. But frequently, as here and as in the Northside case, when a private entity is alleged to be in possession of public records, it's not cut and dry. It's not something that can be addressed in 3 days. The Northside litigation dragged on for almost 7 years before Jones Day finally dismissed it, hotly litigated over whether the records were even applicable. So we would just urge the court that not applying the 3-day standard to Stadco in this case is not allowing Stadco to take advantage of a loophole. And again, understanding that the court meant nothing pejorative thereby. But not applying that standard is not something the legislature didn't intend. It's rather part of the structure of this statute that recognizes that very frequently private entities have much to say about whether their records are actually subject to this act or not. And it's usually much more muddy than if an agency is refusing to hand over records or refusing to respond to a records request in 3 days.
Sure. If I used the word loophole, one wasn't what I meant, and it certainly wasn't to suggest there was something good or bad. The statute is the statute. It excludes private entities. The way it's written, the agency has 3 days to respond. It doesn't say anything about private entities. So I wasn't disappointed or displeased with the statute. I was just asking Mr. Kendall to give his perspective on how, if at all, the 3-day requirement came into play here, because one thing both sides agree on, Stadco is not an agency. Whether it is acting on behalf of an agency or not, there's the heart of our dispute. But Stadco is not an agency, and so the 3-day window didn't necessarily apply here. And so I was just asking him to comment on that. But your points are well taken. I didn't mean to create consternation on either side if I use the word loophole. It's just, it doesn't include private entities. It says agency. Mr. Hendrick, anything you want to cover beyond the topics that we've already covered with both sides?
Only one thing, Your Honor. The question, and this really gets to the heart of the Northside decision, the question isn't binary in that, is Stadco in possession of any public documents, and it's just yes or no, and if the answer is yes, you're allowed to have whatever you've asked for. Northside introduces, not for the first time, but focuses on this idea of connectedness. A person seeking to establish that certain documents in the possession of a private entity constitute public records has to show a connection between the document that is being sought and the specific governmental function that is being performed by the private entity that a agency would otherwise have to perform. And we pointed this out in our briefs, and we hadn't really talked about it today, so I just wanted to bring up at least this one time. And there really has not been any evidence introduced by the plaintiffs identifying the specific governmental function that plaintiffs contend Stadco is performing that the GWCCA would otherwise have to perform, and then linking that function up to a lending agreement between Stadco and its private banker. The GWCCA was not a party to that, and plaintiff has just tried to throw everything against the wall and say, look at all these things that Stadco is doing, and because they're doing this and because the GWCCA used to do it, we're entitled to all of these documents that we have requested. But there has not been that link to establish why these private contracts between Stadco and Bank of America are somehow linked to a specific governmental function. And that is required under Northside, and there's no evidence before the court on it. And that's the only other point I wanted to raise at this point.
Okay. I guess I see that Mr. Kendall has articulated and shown through a bunch of the SLMs, the agreements, the functions that Stadco is performing that GWCCA is authorized to perform. And so I don't know that that's the strongest argument for Stadco. It is a requirement that has to be shown, the connection. You know, if Stadco were building something on the property that was not within the ambit of GWC, a telecommunications tower, and it's nothing that GWCCA was authorized to do, then maybe there's not a connection between GWCCA's role and what Stadco was doing. But this is in GWCCA's wheelhouse. I don't know that that ultimately would be a winning argument for Stadco, where I think there is a lot of traction made in your briefs on behalf of Stadco is that GWCCA is not obligated to, required to, mandated to have a sports arena. It can, but it's not mandated. And to me, that's the fulcrum we're balanced on, is the have to perform requirement part of on behalf of. I think Justice Peterson says it is, and that's what Northside says. And Mr. Kendall has argued powerfully that that sort of does away with any private entity ever being subject to the ORA, and I'll need to work through that. So I'm not disagreeing with you that it's an element. I just don't know that it's one that, Mr. Kendall hasn't met, and two, that there'd really be a big issue before a fact finder about whether what GWCCA is doing, what Stadco is doing is something that GWCCA might otherwise be doing. Not that it has to, but that it might otherwise be doing. But it's a point well taken that the lending agreement, which is all that's left in the dispute, was between private entity 1 and private entity 2, and not GWCCA. Mr. Kendall, anything you want to say in response to that?
Yes, Your Honor, very briefly, and I can't find it right now in my documents, just looking through them real quickly here to that point, but the Georgia Dome was financed by the state of Georgia. Stadco financed the Mercedes-Benz Stadium. And there's a funding agreement that I think is an exhibit to my motion for summary judgment that documents their obligation to fund that construction of that stadium. And I believe that in some of these documents, there's also a reference to the fact that the Georgia World Congress Center financed the Georgia Dome. So there is the connection between the financing documents that Stadco is in possession of and the financing agreements that were evident and are on behalf of the Georgia World Congress Center financing of the Georgia Dome. The two are connected in that respect.
Okay. I think that's it. I will take this all under advisement, aided by today's argument, as well as the substantial briefing that has occurred across the various motions that have been filed here. I will endeavor to get an order out as soon as I can. Mr. Kendall, anything else procedurally we need to talk about today?
No, Your Honor.
Okay. Mr. Hendrick, anything for Stadco?
No, Your Honor.
Okay. I trust the lawyers will sort out with Ms. Crump her situation. She has been dutifully taking down everything we've been saying during this virtual court appearance. I will take it from here, and Ms. Niles will let you know if I have any other questions or need sort of memo briefing on a particular issue if I'm wrestling with something, but I don't think we'll need any additional formal filings for me to work through where we are right now. I appreciate everyone's patience on this one, and we'll be back with you soon. Thank you.
Thank you, sir. All right.
Thank you, Your Honor.